Hey guys, welcome to the blog today. So, today we're going to talk about the state of New Jersey. So, yes, I did at one particular time work in New Jersey, but it seems that they've passed a privacy bill. And they're the growing list of states this year that are taking on the privacy, are taking seriously the privacy of their citizens. So, of course, when you have these legislations, the it gives the state attorney generals the right to sue for any breaches of privacy. But this particular privacy bill they all come in different flavors, which is to the dismay of many of the companies that are, if they're operating in multiple states, they have multiple laws, similar to the data breach laws. I mean, don't get me started about data breach laws and the differences between the two and the different flavors that they have depending and whether they are biometric data. Okay, anyway, so let's talk about New Jersey. So basically, this particular law applies to companies that collect personal data, which includes your Googles and your, Facebooks of the world, everybody that collects personal data. And it gives the consumers the right to get information about what that company has about them particularly. Um, and they have to the actual entity has to explain to the consumer in plain language. You'll see that a lot, and we'll get back to that in a minute. In plain language, what they're collecting and how they're going to use that particular data. So, of course, it's the lawyer's fault that plain language is in there, because if you read some of these notices, which no one ever does, it always clicks through the privacy statements that are every app or whatever that you sign up for tells you, and it's written in this very complicated legalese language too. And okay, yeah. Okay, it's the lawyer's fault. I can admit that. But these complicated languages, and consumers don't read them, and even if they read them, they may not necessarily understand them and what they're saying. And so that they're saying they have to provide this plain language, basically tell consumers in plain language what they're going to be doing with that data. And so, and then you'll see a short form and a long form, for the lack of a better word. You'll see a privacy notice that's short and plain language, and it'll link off to the more long legalese language or whatever. But it's supposed to be like a summary of that data. And you're seeing that a lot in a lot of these privacy legislations that are saying you got to tell the consumers in plain language what's going on. And lastly, the consumers will be actually have the right to ask the companies to delete their data. Um, and so if they have their PI, they have to delete it. Did I get them all? Yeah, I think I got them all. And so that right there is always the complicated thing, because if you are collecting data and then you are selling that data, and then the consumer says delete that data, now you have to go through to all those parties that you've now sold that data to make sure they're deleted. Because again, as I've tell my clients all the time, the relationship is between the consumer and you, not necessarily the consumer and your third party. So if you're selling that data to a third party, you have to ensure that that third party has the same controls that you have in place to delete that data if a consumer comes in and says delete that data. That's where the technology aspects comes in, and that's where, knowing where your data goes in. That's why I can't in my own mind separate, cybersecurity and privacy, and because it's like, okay, so I come in, I give you that data, and then I'm dealing with this. You use back-end systems and all this other stuff that has cybersecurity requirements on it, because you have a requirement as the company receiving my data to protect that data, and then it flows downstream. So when you hire somebody else, or maybe you have a software provider, or maybe you have someone else that's processing a piece of this data, of course you have to be able to go back to them, being that third party, and telling them you have to do the same thing I'm able to do, because if a customer comes back and says delete the data, it has to be deleted everywhere, not just in that, not just with the individual that the consumer actually interacted with it initially, but all the downstream providers. Um, and again, I guess it was the Internet Association, which is a trade group that that is for big technology companies like Google and Facebook and Apple or whatever. It's a trade group, and they basically said, "Oh well, the state should stop um, producing these privacy legislations because there's going to be a bunch of inconsistencies, and they should wait on federal legislation, federal comprehensive privacy legislation." That's yeah, but the privacy regs or the regulations from the federal government perspective, there's absolutely no reason to believe that that's going to happen at anytime soon. And this anytime soon, and the states have to understand they have to protect their citizens. And again, it is still a revenue generator for the states. I mean, when you think about it, all these breaches are happening. The FTC comes in, they fine or whatever, and then or they come in, they do an investigation, and then the company settles. That money goes to FTC in the states. So I mean, state attorney generals, if they're smart from a revenue, just strictly capitalist, nonsense. From a revenue generation perspective, I have a company that's doing business in Texas, and they're collecting data, and no Texas legislation. FTC comes in, FTC gets money, but these are my citizens, right? So it becomes okay, well, privacy regulation for the individual state. The attorney general has the right to go sue that particular company as well for violation of privacy laws. They give the state and FTC the right to sue, but they don't give you as an individual person the right to sue for a company losing your data for lack of security or privacy practices at all, right? It is twisted, and I understand the rights, and I don't get me wrong. Yes, the states need to do this, but it's not as altruistic as they would like to say, because again, you breach, that money goes to the state. So sorry that I had to say that, but I mean, I did. I mean, if they actually wanted to give the power to the individual consumer, then give the consumer the right to sue for the loss of their data, or at least create a statute that says something to the effect of, for every loss of the data, that particular consumer gets an automatic, $500 for each violation. I don't care how it's drafted or how it's written, but if you want to make change in the cybersecurity and privacy space in regards to these data breaches that are happening, you have to hit the company in a pocket. And 5,000 records being lost, $500 a pop, that gets someone's attention. If it's just an automatic, this is how much, I don't care if they can't prove that it's no damages. You should have taken care of that data. If the investigation holds that you were negligent in your ability to protect that data, and we'll talk about that in the random thought about a risk assessment, risk analysis. But if the evidence shows that you were negligent, then it should be an automatic fine, and it should go straight to the consumer. That's Mary's thought for today. Stay tuned for the random thought. Thanks. Is it time for your annual wellness check? Cybersecurity and privacy programs, once implemented, can't get stale. It's very important that you take a look at those at least on a regular basis or semi-regular basis to ensure that you are complying with industry best practices, that there haven't been any laws implemented in your state that actually affects what you're doing from a day-to-day perspective. Whether it's, trying to figure out, do I need cyber liability insurance, and what kind of insurance should I purchase? So it's very important to take a look at those programs. If you need a wellness check, please reach out to the Cybersecurity Law Firm of Texas for help. Okay, random thought for today, guys. Okay, so hanging out on the HIPAA, the Office of Civil Rights website, and I saw this particular breach, or this particular fine that was paid by a individual medical practice. I guess it was the practice of Stephen A. Porter, MD. I think it was out of Idaho. I think it was. I could go check real quick, but I didn't write that down in my notes. I think it was out of Idaho. That essentially the actual individual had a breach. They actually got into a disagreement with one of their business associates, and then it's in Utah. I did a quick check. Sorry, Utah. But they had a issue with one of their business associates. The office had to report that they had this breach, and OCR came in and slapped them with $100,000 fine. Now, the $100,000 fine was for their failure to perform a risk analysis. Um, so the question becomes, what is a risk analysis? So if you're out there and you collect data, if you're a small practice, if you're a dentist office, if you're just collecting information, especially in healthcare, because HIPAA is mature enough, they're paying attention to these little bitty offices. GDPR is still huge. They're paying attention to these huge breaches. HIPAA's been around there for a while, so you have a small office and you have to report this breach of data, then they're paying attention. So a risk analysis. So anything that you have to do when it comes to cybersecurity and privacy, you have to determine, logically speaking, how you're going to attack whatever those risks are. If you don't know what the risk or the danger of losing that data is, how do you know how to protect it before you buy the technology? Now, I'm not saying when you go back and you look at the effectiveness of your technology. Okay, let me stop. I don't say that you don't do anything right off the bat before. I say once you're in business, you're in business. But when you perform a risk analysis or a risk assessment, you go back and you look at what the processes are. You look at the requirements under HIPAA. If you're a healthcare office, you look at the contractual requirements, because if you do business with the federal government, you have cybersecurity and privacy requirements in those documents, right? In those contracts. You just can't check, which many small businesses do, and then they get in trouble for it. So there are contracts if you're doing business with a bank, if you're doing business with that's one of your clients, you have cybersecurity and privacy requirements that are in those documents that you actually have to see. What do I have to do? What am I required to do? Where am I from a maturity perspective? How much money do I have? Because I can guarantee you $100,000 for this particular medical practice, it wouldn't have cost them $100,000 to do a risk analysis. It wouldn't. I don't charge my clients $100,000 to do a risk analysis. The risk analysis is a short piece. It's the implementation of exactly what you're trying to do that's important. So it's identifying, okay, I have these 5 things that I really have to do. Okay, so which one am I going to do first? How much money do I have in my budget? Let's say it's $100K. And how much can I get? How much bang for my buck? How can I reduce this risk all the way down to where it's acceptable to me? So when and if I have a breach, when the Office of Civil Rights comes in, they can actually see the documents. Say, see, I was here. I got to 3. I know I needed to do 4 and 5, but look, I have insurance. And so they can come in and say, okay, well, you've actually logically thought through this process. And now you can prove to us that you just didn't do anything. And that's what happened in this case. They just didn't do anything. Gone are the days that you can just not do anything and not get caught, because it's going to cost you some money. So hopefully you guys know that, and you performed or are performing your risk analysis. If not, of course, you can call the Cybersecurity Law Firm of Texas. We could do that for you, right? You guys have a great day. Bye. Thanks again for listening to the Breach Whisperer blog, sponsored by the Cybersecurity Law Firm of Texas. Don't forget to like this post and subscribe to our channel so you can get updates of when we post new things on our channel. In addition, spread the word for me, right? Let's get out there and tell a friend, and so they can all become paranoid cybersecurity and privacy people. Don't forget, if you would like to connect with me on socials, you can connect with me on Twitter. At Mary N. Chaney. Use my middle initial always. For my nonprofit, Minorities in Cybersecurity, that is at Mike Leadership, and Instagram and Facebook at MN Chaney Law. And you can find me on LinkedIn just by searching for my name. So if you're interested, connect with me. Thanks again. And just remember, awareness equals knowledge.